According to the High Court judge, Justice Gifty Agyei Addo, the application for injunction, if granted, could prejudice the entire suit before her. She also noted that the application failed to appreciate the difference between interim injunction, which lasts for 10 days, and an interlocutory injunction, which lasts until the final determination of the substantive case. Hence, the applicant cannot apply for both injunctions at the same time. Justice Gifty Agyei Addo continued that if she was to grant an interlocutory injunction, it would constitute a travesty of justice because the respondents in the matter had not been put on notice and heard. However, Justice Gifty Agyei Addo says she will expeditiously determine the issues before her, ordering that the respondents must file their response to the suit within 7 days after service. The applicant was urging the court to compel Achimota School to admit him to further his education. This application for interlocutory injunction was filed pending the determination of the substantive case filed in court after Achimota School refused to admit the applicant and another Rastafarian student who declined to cut their dreadlocks. But father for one of the Rastafarian students, Iras Marhguy, says they have started taking their children through homeschooling.
He's already started his education online, and there are individuals that come in the house to actually give him some teaching. Remember, he was taught at home before he did the homeschooling, right? So that is not new to us in terms of keeping him up to the level so that when the exam comes, he will be able to deal with it.
Iras Marhguy added they will follow the case until justice is served.
But it is necessary for us to pave the way for future generations of Ghanaians because, as my sister just said, a whole colonial law in this time is using to disenfranchise Ghanaians with impunity. It is necessary for us to ensure that this doesn't happen in the future.
Meanwhile, a member of the legal team of the Rastafarian students say they will comply with the court order to serve Achimota School immediately for the substantive case to be heard.
But by her order, when we serve this ruling on the parties, that is the respondents, that is the Achimota School, the GES, Ministry of Education and Attorney General, when we serve today's ruling on them, they have only 7 days and no more 21 days. The rule says 21 days, but the judge is saying that because she wants to deal with this substantive matter itself, the enforcement of human rights, that is what she wants to deal with, and not take somebody in for 10 days, and then after 10 days, you come back again for another application. So in her mind, she's not too convinced, especially when the Achimota School has not been served with a substantive matter.
Lawyers for the applicants were hoping that the court will grant the application for injunction after arguing before the court that if the case lasts for a longer time in terms of the actual trial, these students will lose an opportunity to study with their mates for at least an academic year. The trial judge refused this application, saying that if she grants this application for injunction, it could potentially have an impact on the decision, the final decision to be made. However, she's moving for a speedy trial, ordering Achimota School and the other respondents to respond to the substantive suit within 7 days upon receipt of these issues. The case has been adjourned to 22nd April 2021 for the substantive case to be heard.